Welcome to the Influential Personal Brand Podcast. This is the place where we help mission-driven messengers just like you learn how to build and monetize your personal brand. My name is Rory Vaden, and I'm the co-founder of Brand Builders Group, a Hall of Fame speaker, and New York Times bestselling author. And this show is to help experts learn how to become more wealthy and well-known. I know you're going to love it. Thanks for being here. Let's get started.
So non-competes are going away. What do you need to know to stay compliant as an employer? So there is a new ruling by the FTC, right, the Federal Trade Commission, on non-competes. Here's what you need to know is that the new non-compete rule is going into effect on September 4th, 2024, right? So as I record this, we are heading into middle of May 2024. So in a short 4 months, this is happening. So there's a cushion of window to get yourself prepared. What does it mean, right? So this new comprehensive ban is federal, which means it is nationwide, not state by state, and it is banning all new non-competes with all workers, right? So employees, including senior executives. So this includes 1099s, consultants, employees, including senior executives. The final rule states that it is unfair to have a non-compete as it's preventing a method of competition. And therefore, they are banning it, right? So that is happening September 4th. For existing non-compete, so anything that is established and in place, I would say prior to today, which is May 14th, right? So as I record this, anything that is before today would be existing. Like if you know about this, it is wise, and I would advise you, not legally, but as a friendly advisor, to go ahead and put these things into place because they're coming, right? So what I'm talking about is pre-signed employee documents that have non-competes in them. For those, this has a little bit of a ruling for senior executives. And then it's different for senior executives than it is for, I would just call them non-senior executives. So what is the defining term of a senior executive? Typically, it is someone who is making more than $150,000 a year, who is also in some sort of policy or decision-making capacity, right? So don't hold me to that to the dime, but that's what is technically considered a senior executive role. They have decision or policy-making power, making more than $150,000, give or take $1,000 or $2, right? So for those individuals, for senior executives, existing non-competes can remain in place, right? So existing can, but here moving forward, again, I'm saying May 14th, like, as you know about this, don't be trying to just hire a bunch of people if that's not in your best interest. But this ban on September 4th also includes new senior executive positions. That will not hold to them. So it will hold if you have a non-compete for existing ones, it will not for future ones after September 4th. So that's the first thing. So if you are a non-senior executive, right? So all other workers different than senior executives, nothing is enforceable after the effective date. It's just gone, right? So existing ones for senior executives will hold intact, new ones will not. And for all other workers, it's gone, right? So all other 1099 or W-2 employees, the non-compete will not be enforceable after September 4th, okay? That's the general thing that you need to know about this. Now, there are some things that you should also know that are not a part of this, technically this federal ruling, which are non-solicitations are staying intact, right? So as non-competes go away, which there are pros and cons to this, right? I used to be in the consulting world, and this would be very advantageous for me in that role to not have a non-compete. But there are some nuances to that thing of proprietary information, confidential information, trade secrets, right? So there are some things that are still going to stay intact for a consultant work for hire 1099, where if I am currently being hired by, X company with certain trade secrets, confidential information, proprietary, whatever. I'm not able to go and compete with a direct competitor with those things during my time frame of work. But as soon as my time frame of work is over, the very next day, no non-compete will be eligible to me, right? So that is very much in my favor, although there's still some protection for the company, for the business owner who is hiring someone to come in. And this is where you just really need to make sure that as an employer, as a business owner, this you get this 4-month window that you really need to meet with your attorney. This is the time that you need to do contract reviews, service agreement reviews for you and vendors. If you hire consultants or 1099, make sure you're talking to your employment attorney about your current contracts, because as non-competes go away, that doesn't mean that non-solicitation is going away, right? So I think it is a fair to go, hey, like, there free market, free trade here, right? If you choose to leave here, you can go do your own thing. Yes, fine, but you cannot take our trade secrets and use them. You cannot take our confidential information. And this is where you really need to get into the nitty gritty, cross your T's, dot your I's in your agreements to make sure that you actually have provisions, you have clauses that does protect your proprietary information, your systems, processes, methodologies, frameworks, your IP, right? Those need to be in your employment agreements. Now, I am not an attorney. This is not legal advice. This is my opinion as a business owner, that just because non-competes are going away doesn't mean that you can't still be protecting yourself and your business, as you want to be free, open, and transparent with your team. Of course you do. At the same time, protecting, trade secrets and proprietary information, as well as keeping your non-solicitations intact, right? So just because an employee at free will decides to leave and go start their own thing, even if it's in competition with you, they cannot recruit other employees. They cannot recruit away your clients, and they cannot take your information and use it as their own, right? So there are some things here that are very much in favor of the individual, the employee, which is fine, right? But that's where you, as the business owner, need to step in and go, great. And now I need to double down in these other areas with confidential information and my IP and non-solicitations and everything else, to make sure that you are fairly protected, right? Not being overbearing, or this is no time to panic. Most non-competes we're holding up in a court a lot anyways. There are many states that have banned this years ago, like California. So yes, there's a lot of talk and a lot of flurry about this, which is part of why we're making this mini podcast right now about it. And at the same time, very few non-compete lawsuits were holding up in court anyways. So this is just kind of like making it a federal stance, overarching of what really was hard to uphold anyways. But it's a great opportunity and a necessary time to update all of your agreements, as well as review and ensure that you do have other clauses protecting your information, your IP, as well as doubling down on non-solicitation, as the non-compete will be no longer allowed. It will be illegal to have that. So you do need to ensure that all agreements are updated. Those are removed by September 4th, because at that point, people can sue. People can turn you in. The federal government even has a website and a form where you can go and submit people who still have this in their agreements. Don't be one of those people, and go ahead and take care of this now. So quick high level update. If you need more information, talk to your attorney, right? That's what you need to do. This is really a call to arms of, hey, big things are changing. Agreements need to be updated. Here's what you need to know. The date is September 4th, 2024. And this is going to apply to all workers, in terms of new agreements for, senior executives, W-2 and 1099 consultants. As well as this does have some implications on existing, which is if you're not a senior executive, all existing agreements, the non-compete will be null and void on September 4th as well. So from here, talk to your attorney, get those agreements updated, and do what you need to do to make sure that you are compliant and up to speed post September 4th.